Hi, I'm attorney Gregory Dell, joined by attorney Stephen Jessup. And Stephen, we're going to talk about what is an ERISA disability lawyer. Now, this word ERISA is something I never heard about in my entire life until I got into this area of practice. But in reality, a lot of people, it affects their life in more ways than they know because of the fact that it governs all employer-provided group disability benefits. And one of the biggest ways that it touches people is in the health insurance world. That if you work for an employer and they provide you health insurance, your health insurance policy is governed by ERISA. And if you have long-term disability insurance, which is what we do, short-term or long-term disability insurance claims, and your policy is provided to you by your employer, then you have what's called an ERISA disability policy. And a lot of people have no idea what this ERISA even is until either they ask for a copy of their disability policy and they see something in the first page that says this policy is governed by ERISA, or they unfortunately get denied their disability benefits and it says you have rights pursuant to ERISA and you can file a lawsuit, or you have to comply, and they're like, what the hell is ERISA? So let's just touch briefly on what ERISA is for a minute. And then we'll talk about the things that we do in what I consider to be a highly specialized area of the law if you are an ERISA disability lawyer.
Yeah, so ERISA is a federal statute, it's federal law, the Employee Retirement Income Security Act, excuse me. So it's federal law that's going to govern your policy, and with that is the nuance of what an ERISA disability lawyer is understanding this really kind of unique area of federal law that most attorneys don't know anything about, never heard of, and like you, until I started working here. When I was in law school, I never knew what it was, right? So it's a very, very important body of law for anyone with a job who gets an employee benefit, but very few people know the nuances, the ins and outs, especially as it gets to the disability side, because I think a lot of people may confuse it with kind of like, well, is it like Social Security disability or something along those lines? It's its own separate entity, and creature really.
And talking a little bit about, ERISA came back, I don't remember, 1973? 74, okay. And it's managed the law. The Department of Labor makes suggestions, but then Congress has to adopt laws in order to amend it. And with that, there's regulations, which is basically about a 30-page document, give or take, which dictates the way in which ERISA claims have to be handled. And that's super helpful because now we have an area of law that has regulations and guidelines that need to be followed. But as nice as that sounds, we also have thousands and thousands of cases that have interpreted the manner in which these ERISA cases are going to be administered. And that's a pro and a con. It's a pro because there is tons of case law out there with opinions on both sides. And it's a con because it's not always so clear in terms of how these regulations should be enforced, what's reasonable under these regulations. And I guess that's why we have a handful of lawyers who specialize and focus in this area, because it's convoluted.
Yeah, to say the least.
So in terms of what an ERISA disability lawyer does, the primary area of our work is helping people that have been denied these benefits and enforcing their terms of their disability policies so that they can get paid, whether it's through an appeal or through a lawsuit. But always when we do this type of work, we know that we're within the confines of the ERISA laws. And so talk about how when you sit down to do an ERISA appeal, and many people who are watching this somehow or another saw something in their denial letter says they need an ERISA denial lawyer, ERISA appeal lawyer, whatever it may be. But they're not thinking like you are about, yeah, I want to win this appeal. But if I don't win this appeal, how is a court going to look at this? What is the case law that's governing this, as opposed to the typical claimant who just gets a denial letter, has to do an appeal, and the insurance company goes, well, just go ahead and appeal. Why do you have to have a mastery of the ERISA laws and understand it in order to put together what I call a 5-star super strong appeal?
Because your appeal is, at a point of a denial, your appeal is the single most important thing you can do for your claim. It is really the lifeline to getting paid benefits again. And anyone who I've ever spoken to, on the phone when it comes to getting a denial, or who I will speak to, I always like to give them what I call that 20,000-foot view of why your appeal is so important, and that is, what you lose in litigation, like what you're not capable of. So before we get into that, the appeal is your final opportunity to establish with an insurance company why you are disabled under the terms of policy. some companies, Lincoln has a mandatory 2 still in some of their policies. Some companies give you voluntary, but more and more you're seeing insurance companies, do away with voluntary and just giving you 1 level. That's what the law says. So you have to go through the appeal process. If they deny you, you can't just sue. You have to file your appeal. And also, if you fail to file your appeal within 180 days, you can be forever barred from filing a lawsuit. But obviously, if your claim's been denied, you want to try to get money as quick as possible. You want to get on claim, and it's easy to be lulled into a sense from the insurance company. You just have to write a letter that you're appealing it and disagreeing with our decision. We'll take a look at it. But if they uphold that denial, anything you could have added to your claim is prohibited to then to be argued to a judge. So the appeal itself is going to be not only trying to get you back on claim, establishing disability, but it's also setting up any argument that you're going to want to have to potentially make against the insurance company in the event you do end up in litigation. So while people are thinking, I just have to write a letter, explain why I disagree, we're looking at it as, how am I convincing a judge what they did here was wrong, right? Because if I can get that established in the body of my appeal, and that's not through arguing case law and telling them everything they did wrong, that's by providing the information I know that courts care about down the road. So the appeal is such an important undertaking. And if people do it on their own and they come to us and then litigate after it's been denied, certainly we can still litigate a case if we think it has merits. But our ability to get a positive outcome is going to be greatly diminished.
The other thing when I talk about ERISA is while the insurance companies are doing what they do to review a claim, most of the claimants who call us go, this insurance company's playing games. Well, there's playing games, and then there's violating the ERISA regulations. While a claimant may think they're playing games, they may be within the confines of the ERISA regulations. How are you supposed to know that as a claimant? You don't know that. But we know that, and they do play the games which are really in violation of the ERISA regulations, and they do it quite often. And when you have a lawyer who knows what they're doing, who's an ERISA disability lawyer, you can put a really quick stop to that. And if you can't put a stop to it, and if you do lose an appeal because they've engaged in conduct that violates an ERISA regulation, then you're going to zing them in an ERISA disability lawsuit, which is the next stage that comes after an appeal. So, this ERISA has lots of nuances, and I've had things out there where I've commonly been known to say ERISA sucks, it's bad, it's not great. And more often than not, I say that because ERISA has standard of reviews that happen after you do this appeal that you spoke about and when you're required to file a lawsuit. And the lawsuit has to be filed in federal court, which means that basically we can file in almost any federal court in the entire country, and we have been in almost every court across the country, which is why we represent claimants nationwide in these particular cases. But when you file this lawsuit, it's not what everybody thinks about. And we have extensive videos that we've done about what an ERISA disability lawsuit is. And that's not really the purpose of this particular video, other than for people to understand that you have to have a lawyer that dances in this area every single day. Not someone who says, oh yeah, on my website I do personal injury, I do this, I do Social Security, and I do ERISA. No. This is so focused because once you go to that lawsuit, how many ERISA cases do you think are out there, lawsuits, court decisions, not lawsuits, court decisions that are out there in the ERISA world?
Oh, there's thousands. I think in federal law, outside of criminal cases, because of the ramifications, things going to Supreme Court, I think in federal law, you probably have more ERISA cases that make their way past district court level into the appellate courts because every circuit interprets it different. Like you said, there's a bunch of law that can be helpful, but then there's another case that contradicts it. So it's an always hotly contested area of the law. So you see lots of cases out there.
And the law has so much discretion left to the courts, where even for years there were arguments about what is the standard review. Courts didn't even know what to do in terms of, is it a de novo review? Is it arbitrary and capricious review? How do I look at this? Am I supposed to defer to the insurance company in this case? Do I not defer to the insurance company? And these are all complicated issues that come up in every one of these lawsuits. But I always call, and it's probably my thing, I call ERISA the wild, wild west because it is absolutely wild. Many judges, they don't even know what to do when they get these cases because the case law is evolving every day. It's different from circuit to circuit to circuit. Another opinion comes out every week. Every day we get these blasts of the newest cases that come out. And then we're like, oh, Well, so much for that theory, good or bad, that was supporting a theory that was always pushed for our clients, which, but we're always on top of that. And you have to have this catalog and knowledge and stay on top of what's going on in ERISA to be able to put your client in the best position possible to win. And I'm circling back because if you're someone who's litigating these cases all the time, then you know how to write your appeal, how to push the company, because you don't want to write, these lawyers who don't do this, they write these appeals and they tell the insurance companies every single thing they did wrong, and they basically tell the insurance company how to do it right. Well, if the insurance company does everything that you tell them to do, then when you go to file a lawsuit, you're going to have a hard time saying they acted unreasonably. Now, what I've noticed lately was even when I tell these companies, they are so arrogant and either so dumb, or let me go back to my arrogant synonym, so confident that they just, even though if you tell them something, they don't care.
They don't care.
They don't care. You're dealing with multi-billion-dollar companies, and they're like, well, if we have to pay your client a couple $100,000 and we're wrong, and we got to pay your attorney's fees of a couple $100,000, then down the road we'll pay. So that's the challenge in this ERISA world. But I think the takeaway from this is a couple things. Whoever you hire, and certainly we hope it's you if you have a case that we think that we can win for you, because we're selective in the cases we take, because it's a challenge in these cases. We're not just going to take a case for the sake of trying to file a lawsuit. We want to take a case that we can win. Why? Because we're not getting paid unless the claimant's getting win. So why are we going to put the time in to a case that they're not going to get paid and we're not going to get paid? Because no one's going to be happy. So we're going to build a relationship from the beginning to say, this is what we think we can do. This is what we think the outcome's going to be on this case, so that we're on the same page, because we become a partner in this lawsuit, which we enjoy, and we want to make sure the client, has that up front. That's super important when you bring these ERISA lawsuits. And I also want clients to understand that they should definitely be hiring someone who has experience. If you don't hire someone who's experienced, you're going to get slaughtered in this ERISA disability world. So that being said, if you have a long-term disability denial lawsuit, even if you're applying, we didn't touch on that. We help at every stage of the claim. Feel free to reach out to us. We're happy to review your policy, review your claim if you've been denied, provide you with a free initial phone consultation. No matter where you live in the country, we'll assist you, and we look forward to the opportunity to speak with you.